All right, hello, I'm Vince Davis. I'm an attorney here in California. I practice in the area of family law, divorce, child custody, and support. And my guest is
Sohaila Umrani, who also practices family law in California.
All right. So from our last video, we indicated that we were going to talk about tonight the RFO, the request for order. So Sohaila, tell me what an RFO is. How do you get it done? How do you get it filed? What happens at the RFO hearing? Go ahead.
Prior to it being called request for order, it used to be called order to show cause. The abbreviation was OSC. I don't know what happened. They changed it to request for order. Both of these, no matter what it's called, it's a request from the court to give an order on certain issues, which is also known as motions. We can also call that a motion. I always was wondering what's the difference between RFO or OSC and the motion. And I finally figured it out.
What is it?
On the motion, you need points and authorities.
Interesting.
Yes, it took me a while, but I figured it out. Request for order, as I indicated last time, every time we ask the court to come up with an order, it's a motion, it's a request. So in family court, we call it request for order. In civil court, it's called a motion. They both are requesting. And I think they called it request for order to differentiate family court with civil court, maybe. It's my guess. For a request for order in family law, it's either for custody, support, or attorney's fees, and there is a box in that in that form that says others. You can ask for others. Now you have to say what you want. You want to travel with the children. You want to bifurcate status. You want the other side to be compelled to do something, produce document. I mean, there's other. You basically design it as you wish. And then after you prepare the form you're asking for something, you need to put the declaration of the client in there, stating the background and why is it that you want what you want, and what's the grounds that the judge should order your request. These documents are prepared. Some people add that points and authorities because they found some good cases that support their position, or some good statutes or law that supports their position, but it's not necessary. The courts can actually hear your case without the points and authorities, except for the ex parte times. So those documents get filed with the court. Once it's filed with the court gives it a date for hearing. If the request is for child custody visitation, the court will also set a mediation prior to hearing with the hope that parties will reach an agreement without going to court and litigating it. So it gives a few days before or the day of, anyways, a date before the hearing, a mediation will be set. Those documents has to be served on the other side. So the other side gets a copy of it plus blank copy of a response with a form. It's called responsive declaration. They also get to read it. They also get to respond to it. Now, if you are the person that is filing the request for order, you get 2 bites of the apple. You file your papers, you wait for the other side to file their answers, and you get the second bite by replying to what they said. All of these within given time, statute time, has to be filed with the court, served on the other side, and on the date given, everybody will appear in court. And hopefully by then the judge has read it, is aware of what's going on. If the judge has any questions, it gets asked and answered. Otherwise, both sides get to argue their cases. And at that point, the court will give its order. So we did file paper requesting for order, and at the time of the hearing, the court will give its order. And that's the bolts and nuts of it.
Let me ask you this. When you file the RFO, how long is it before you actually have the hearing in front of the judge?
It depends. It depends on the court's calendar. There are, I filed a motion to be relieved on a very famous case in our firm, and I had 2.5 months later the date, and it hasn't even come up yet. But I have had some filings in different court that wasn't that busy, and I had less than a month. Remind you, when you file your papers, you have to serve the other side personally 16 days prior to hearing, or you add 5 days for mailing or 2 days for emailing it. So at least between the time that you file it to the time you get a court date, it has to be at least 21 days. So normally within a month, you get a date, if you're lucky and the court has time.
Once you get to court, you filed everything, you finally get to court, you walk in, what's the first thing you do?
Well, there's a requirement which is called meet and confer. So it is required that parties sit down and talk to each other. Well, that is either done prior to the hearing or it happens in the hallway of the court. What do? I take my last shot and try to solve it in the hallway. Maybe we can come and reach an agreement. I'm very much pro-agreement. Love litigating, but I'm pro-agreements. So yes, I do approach the other side, and I try to at least reason, or meet the other side halfway, and try to reach an agreement. A lot of times it happens, but sometimes no. Then there's no other choice but to litigate it.
So when the judge calls your case, is it just oral argument? Are there witnesses that testify? I mean, what happens during the hearing?
There are requirements if you want to bring in witnesses. You need to properly file certain documents saying, hey, judge, we're notifying you and we're notifying the other side saying, we do have some witnesses which we wish to take their testimony. A lot of judges, they give you a different date for what's called evidentiary hearing. And they tell you, well, today I give you half an hour, but I set your matter for an evidentiary hearing so you can bring in your witnesses. But if it's a short matter, we go to court, assuming we notified the judge, right, that we have a witness. The judge will hear from the witnesses. If the declarations are not enough and the judge want to hear from the parties, then the parties could take the stand and be questioned and cross-examined. It's very rare that's done that way since clients from both sides have put in their declaration and there's nothing more, supposedly there's nothing more than what they have submitted to the court for them to tell the judge. Normally it's ruled based on declaration, unless something new has happened and the court needs to hear it.